The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Welcome, everyone, to the December 21st sitting of the Appeals Court. We have one case that we will hear today. My name is Mary Thomas Sullivan, and your panel today will consist of me and Justices Hand and Walsh. All the usual rules apply in our Zoom hearings as they would were we appearing in the courtroom. Each side gets 15 minutes and there will be no rebuttal. If there are technical issues, we will address them. And for those of you who may be watching, if you see any of us look to the side or look away, we mean no disrespect. We have our case materials to one side of our screen or another, and from time to time, we may need to refer to them. With that, we will call our one and only case, which is 22P0458, Commonwealth versus Anthony Stokes. Attorney Vizone.
Thank you. If it pleases the court, Joseph Vizone for the appellant, Anthony Stokes. This is a typical case, Your Honors, of dueling credibility. Obviously, the defendant says, I didn't hit my former girlfriend, and the former girlfriend says, oh, yes, you did. And so the trial strategy would have to be to impeach the credibility, obviously, of the complaining witness, which is what the trial attorney attempted to do, but it seems that the court made a number of rulings which we believe were not correct in the law, and that precluded him from having any sort of a trial strategy or a trial strategy of impeaching the complaining witness. For example, the first issue that I raised in the brief was Ms. Tina Brown was on the stand. She's the woman, as you know, who picked up Mr. Stokes after this altercation. And her testimony would have been that, I arrived there, the woman was walking back and forth, and I didn't see any marks on her face. She was saying some pretty bad things about Mr. Stokes, but she couldn't remember the address she went to in South Boston. And so the Commonwealth's position obviously was, we're contesting whether or not the woman that you saw when you picked up Mr. Stokes was in fact the victim, the complaining witness, or was it some other individual that he just happened to go over that person's house at the time. And so because Ms. Brown could not recall the address where she went, they tried to refresh her recollection with a copy of the complaint. And the judge says, oh, no, you can't do that. That's not something that she authored. Well, that's not the law. You can refresh somebody's recollection with anything. In fact, I remember many, many years ago in law school, the professor said, you could refresh somebody's recollection with a pack of cigarettes, and he held up a pack of cigarettes. And because it's not the pack of cigarettes that's the evidence. It's what it does to click the person's brain into remembering something that they need to remember.
While I might agree with you, I like the pack of cigarettes example, and Woodbine is an interesting case. But it appears that the judge didn't actually end up ruling on the issue because it turned out that there really wasn't any dispute. The judge says, is there a dispute about this, that she went to that address? And the prosecutor says no. And the judge says, I don't see a dispute of fact here. She went to that address. There may be a separate question about who she saw there, but she went to that address, and then defense counsel moves on. So how is it that we assign error to the judge, even if the judge misspoke?
Well, again, I take issue with the court as to whether or not that's the address he went, because my recollection of the prosecutor saying to the court that we are contesting says Ms. Brown testified that she had never met the victim prior to the incident on August 6th. the identity of the woman Miss Brown observed yelling at Anthony was contested by the Commonwealth at trial, and that's at.
Well, that's right. The judge said who she saw there is a different issue, but that she went to that address was uncontested.
Well, again, if you can refresh somebody's recollection at the address she went to, perhaps she could have said, you know, that's well, again, she didn't know Miss Rankins prior to that, so that is that's somewhat problematic. But she should have at least allowed trial counsel to refresh the woman's recollection, and perhaps by doing that, she would have been able to say, you know, well, you know, this woman in the court is the one. I mean, the victim was present in the courtroom, so she could have said, "That's the lady I saw." You know.
Your argument is that if the witness's recollection had been refreshed as to what address she went to, it would have changed her testimony that she had never seen.
Well, no, if she never saw, she never saw. But I guess the point I'm trying to make is,
I thought she testified that she didn't know who this person was when she drove up.
In terms of knowing, you know, the person's name, but the victim, Miss Rankins, was in the courtroom throughout the entire trial, and she could have said, "That's the lady I saw." I don't know why that didn't happen. But I mean, clearly, if she saw Miss Rankins, and I'm assuming, you know, he calls up Miss Brown and says, "Come pick me up." Well, that kind of means he doesn't have a car. So how did he get from one place to another place? And who is this mystery woman? All of a sudden, it shows up that he's having this argument with. I mean, there seems to be a reasonable inference that could be drawn there that it was Miss Rankins from all the available evidence that we had.
As a matter of fact, when counsel continues to question the witness, he says, "And when you saw Miss Rankins," and she says, "Yes." So it didn't really seem like, didn't seem to me, reading the way it went, that was the concentration. And it looked more to me like he was trying to show that there was an opportunity to observe Rankins, and that the witness hadn't seen any bruising.
Correct. I mean, first of all, you have to prove that the woman that Miss Brown saw was in fact the complaining witness, and her testimony was, "I saw this woman, and I did not see any marks consistent with the beating."
And that only works for the defense if the woman's Miss Rankins, right?
It only makes sense if the woman is Miss Rankins. Right. I mean, that goes without saying. It has to be irrelevant if it was some other individual. But if I can move on to the second issue in the brief. Well, Miss Brown said that this woman was shouting things, sexual innuendos and other unpleasantries towards Mr. Stokes. And, you know, he asked Mr. Stokes, trial counsel asked asked Miss Brown what this woman was saying, and there was an objection. And you know, they said, "It's hearsay." Well, you're not offering it for its truth. I mean, this woman was saying things that, you know, making sexual innuendos about Mr. Stokes. You know, no lawyer is going to say that he's offering that for its truth. It's offering it to show what this woman's state of mind was, and circumstantially what her state of mind is would prove that this is the woman that's at issue here. This is Miss Rankins. I mean, there's all these little pieces of a jigsaw puzzle here that we want to put together. This is another little piece.
What is the state of mind that you say this shows?
Well, again, she you know, she's saying bad things, yelling at him, screaming at him. We know there has just been a fight, and you know, again, the Commonwealth is contesting the identity of the woman that Miss Brown saw. And again, all of the things she was saying about Mr. Stokes, one can infer, well, this, he doesn't have a car, so he couldn't have gone somewhere else. He must be still there at the scene of the quote unquote beating. And this woman is yelling and screaming and saying all kinds of bad things about him. Is there a reasonable inference that could be drawn from all that this is in fact Miss Rankins and not some other woman that just came out of nowhere?
Well,
I think that's the point.
Is that really at issue on appeal, given the nature of the judge's findings? I mean, the finding of guilt must mean that he thought it was Miss Rankins.
Well, the point is Miss Rankins, I mean, first of all, you have to prove this woman here is Miss Rankins. And Miss Brown says, I looked at this woman and I didn't see any marks on her consistent with a beating. So I didn't beat her. If I beat her the way she said I beat her, she'd be, there'd be blood, there'd be obvious marks on this woman. He hit her around, alleged to have hit her around the head and in the knee, although, the head portion that Miss Brown, I think, would probably be looking at. And, she says, I didn't see any marks on this woman. So if there's no marks, how could he have beaten you? So that impeaches the credibility of Miss Rankins. But again, you have to show that the woman that was there was Miss Rankins and not somebody else. And, looking at all the evidence put together, it seems, pretty far-fetched that all of a sudden another woman shows up at Miss Rankins' apartment. Again, he called Miss Brown because he needed a ride. So he didn't have a car. He couldn't have gone somewhere else and then mysteriously finds this other woman who also hates him just as much as Miss Rankins does.
So what do we do about the fact that the defendant offered to, quote, rephrase my questioning to avoid hearsay problems?
I'm sorry, Your Honor, I couldn't hear you.
The defendant said to the judge when the objection was made that the counsel said he would rephrase his question to avoid hearsay problems. And at that point, the judge said, fine, I'll strike everything, but I'll allow in that she was being belligerent.
Well,
so if you make an argument, how are we on an appellate level to deal with your hearsay argument when trial counsel said, fine, I'll rephrase my questions to avoid the hearsay problems?
Well, with all due respect to trial counsel, it wasn't hearsay. I mean, hearsay, you have to offer it for its truth. It has to be a declarative statement. Okay, it can't be an interrogatory because you can't state a truth with an interrogatory. It has to be a declarative statement, and it has to be offered for its truth. Nobody would be offering for its truth what this woman was saying about Mr. Stokes. So, trial counsel was wrong. He should have said to the judge, it's not hearsay. I'm not offering it for its truth. I'm offering it to show the state of mind of this woman, and circumstantially, by showing her state of mind, it proves that she really is Miss Rankins and not some other woman who just happened to show up unexpectedly and got into a fight as well with Mr. Stokes. And then again, once you prove that it's really Miss Rankins and not somebody else, then Miss Brown's observations make sense. I would move on, if the court would allow me, to the last one about the cell phone. Again, I don't think that the only person who could lay a foundation for the admissibility of the cell phone text was the defendant. Miss Rankins would know that cell phone. It was on her account. And trial counsel could have shown her the phone as he wanted to and said, is this your phone number on the text? Because texts always have the sender's phone number. It's always there on the text. I don't know, maybe she'd say yes, maybe she'd say no. If she said no, then it's, I don't know where you'd go from there. But you didn't need Mr. Stokes to waive his Fifth Amendment privilege to get on the stand just to lay a foundation for the admissibility of the cell phone. I think she could have done that. And then he could have said, is that your text? Is that your phone number? Yes. Is that your text? Yes or no? I mean, again, I don't know what you'd say, but for the court to say you can't bring this cell phone text in through this witness, I respectfully disagree with the court's ruling, and it should have been brought in because, yes.
Ms. Zone, even if we accept that argument as true, given the fact that the judge acquitted your client of one of the two charges against him, both of which depended upon the victim's testimony, where's the prejudice?
Well, he was convicted of one crime, and juries do things. Sometimes they cut a defendant a break and they acquit him. And I'm sure that when you have a jury waive trial, judges do the same. And again, if you believe what the witness, the judge is the finder of fact. She can believe whatever she wants to believe because she's the judge and the jury. And she decided, I'm going to believe everything consistent with an assault, and I'm going to disbelieve everything with the other charge. So that's her prerogative. She's the finder of fact. And so there's prejudice. He was convicted of a crime, and he wasn't allowed to put his case in to defend himself because of these evidentiary rulings, which I believe were all incorrect. I have 8 seconds left. If there's no other questions, Thank you.
Thank you very much.
You're welcome.
Attorney Campbell.
Thank you. Good morning, and may it please the court, Kaylin Campbell on behalf of the Commonwealth. We ask you today to uphold the defendant's conviction. I'll start in the same order my brother did with the refreshing of Tina Brown's memory. I think it's important that defense counsel withdrew his attempt to refresh the memory because the prosecutor was not disputing that is the address that the defendant went to. More than that, in the record itself, it supports that Tina Brown testified that she went to the victim's address. Specifically, she said yes and affirmatively to a question posed whether she drove to the victim's address. So I don't believe, even if it was an error, there would be any prejudice there. Turning to the second issue that my brother argued, the hearsay issue. Again, it's unclear to me, setting aside that the defense counsel said that he would rephrase it, asked her not specifically to state what the hearsay was, and that she gave a non-responsive answer. Tina Brown undoubtedly was allowed to testify as to the state of mind of this woman. She testified specifically, and this can be found on volume 2, pages 8 through 9, that the woman was acting weird, laughing, yelling at the defendant, and she described her demeanor as very belligerent, which would be the state of mind of the woman making these statements.
Didn't the judge strike everything but the belligerent, though?
I don't believe so. If you look, I think she struck that she was like yelling out sexual innuendos about Anthony to me. I don't know if she was threatened by me picking him up or what the situation was. She struck that part. There were 2 questions before. Could you, and this is found on pages 8 through 9. She was able to testify on that she was yelling, laughing, acting weird. She agreed that she was angry. And then she answered, she was laughing, she was yelling. I'm just trying to explain what was going on. She was yelling. Then comes that sexual innuendo part, and then comes the very belligerent. All
right. So you're saying that when the judge said, I'll strike everything else about what she said, but she was being belligerent. This is on page 9 of volume 2. You're saying that she therefore struck only the statements and not the other descriptions of demeanor?
I believe so, because there's no objection to those. Those were questions before. There's an objection specifically to the sexual innuendos about the defendant. So I think it's a fair reading that she struck it. Either way, she gets out that she was belligerent, which I think is the, if you're thinking about state of mind and inferentially that this was the victim, critical to a state of mind, what was this declarant state of mind. Either way, I think, my brother's argument was largely that this stripped defense counsel of the ability of arguing that this was the victim. It didn't. There's still inferentially, and I'd say directly, where Tina Brown stated that she went to the victim's address, information that supports it was the victim. I think it's a fair reading that the judge, who is the finder of fact, either discredited that didn't find that this was the woman, or found that this was the woman and discredited Tina Brown stating that she didn't see any injuries, which makes sense if you look at the verdict. What the judge appears to have done is there were photographs which were omitted of the victim's injuries. She credited that the victim was injured because there was independent corroborative evidence, and discredited the other parts of which there wasn't this type of independent evidence. Turning to the last issue, which my brother argued, the text message issue, this should be reviewed for an abuse of discretion. I think what's difficult when you're looking at this is the way that trial counsel attempted to authenticate these text messages. It wasn't turned over to the prosecution before. Typically, when you see text message type cases, there are phone records. And so it's not actually handing the defendant's physical phone to an individual on the stand. I think that specific practice would raise questions because the witness may not necessarily know how things are stored in another person's cell phone, or there isn't the same type of assurances that it hasn't been tampered with or modified in some way. That phone records, there are those assurances that that hasn't happened. Either way, not that the Commonwealth is conceding that it was error to not allow this, but even if it was error, the defendant hasn't shown that he was prejudiced, specifically because Tina Brown was permitted to testify about the messages that she saw, and that the messages came from Brandy, that the messages were on the defendant's cell phone, and that the messages happened after the assault, and that there were calls that happened after the assault, which directly impeached the victim's testimony. Even more than that, the defendant was acquitted of the charges which would have related to this text message. So it's unclear to me what the prejudice to the defendant would be.
Well, I think that the claim is that the text messages were friendly text messages. What do you say to the defendant's argument that the defendant shouldn't have to waive his Fifth Amendment privilege in order to authenticate? Do you agree that there are ways in which the witness could have authenticated?
I do. Hypothetically, well, not hypothetically, I do believe that there are ways in which text messages could be authenticated in a case like this by the victim. I don't believe the way that trial counsel attempted to do so in this case, that it was an abuse of discretion for the judge to prevent him from doing so.
Well, she had testified that she had no contact, and
Right.
the judge may have made the leap from there. May have made a leap from there, which went untested. Do we have anything in the record to suggest that the defendant asked to have the witness look at the phone or made an offer of proof about what would have been what he would have asked?
No, and even more than that, we've never had an offer of proof of what these messages actually were. It was just that messages were sent. So there is never even an offer proof of what these messages were. And unfortunately, this is the part of the record that had to be reconstructed.
Right.
But there was a sidebar. It's unclear what happened at the sidebar. What is clear is that the judge expressed concern first how this was being brought into the trial at all, that there was no notice, that nobody knew about this.
Well, is that required if you're going to use it on cross to discredit a witness? Do you have to disclose, if you're a defendant in discovery, your best material for cross-examination?
I would say, and this wasn't raised, typically when I file a motion for reciprocal discovery, I do ask for statements of impeachment, that a testifying statement that could be used to impeach them, so you aren't in this situation. So I think it is not out of the realm of possibility that would be required to be disclosed. I think it routinely is ordered by judges. Not so sure in the Superior Court, but definitely in the Superior Courts, at least in Suffolk County.
Okay.
That being said, I can understand a judge sitting there having concerns where it isn't even the phone records themselves or screenshots or anything. It's the physical phone itself.
Yeah.
And so I think the abuse of discretion standard has to be, and it necessarily thinks of the unique circumstances in which these arise. Certainly presenting a defendant's phone itself is a different situation than records, than screenshots, than another way. Do I think that, had this been done in a different way, attempted to be done in a different way, that this would be an entirely different analysis? Absolutely. And I would agree with Your Honor that a defendant doesn't necessarily have to waive his fifth in order for this type of evidence to get in. Either way, in this case, the court need not reach that issue because there is no prejudice given Tina Brown's testimony about the messages and the acquittal of the defendant of the threats charge. I'm happy to answer any other questions that the panel may have. Otherwise, I rest on my brief. Thank
All
you.
right. Thank you very much. That concludes our hearing for today, and we'd like to thank our the court personnel, the IT folks, the clerk's office, and our